A very good evening. I bid to Mr. Surinder Singh. We are from Group 10, Nik Wan Associates, comprising of Atiq Hami bin Supandi, Khairunnisa binti Zainuddin, Nasyuha binti Nik Ahmad Rizal, and me, Alwani binti Ahmad Tajidin. And we would like to present our assignment question which had been assigned to us.
My name is Atiq Hami bin Supandi. I will discuss on the first main issue, which is whether the evidence given by Detective Sergeant Amar Singh as agent provocateur is admissible in order to convict Hassan, who has been charged under Section 39B 1A of Dangerous Drug Act 1952. Okay, before we further discuss on the issue of agent provocateur, so we would like to discuss first on the issue of whether Detective Sergeant Amar Singh is a competent witness to be testified before the court. Okay, according to Section 118 of Evidence Act 1950, all persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or giving rational answers to those questions by tenacious, extreme old age, disease in terms of body or mind, or any other cause of the same kind. Next, I will refer to the case of Muhammad Zuki bin Ali alias Muhammad against PP, where the court held that a non-compliance of the requirement to determine the competence of the witness before being testified cannot be disregarded. Applying to Section 118 of the Act to the present case, Detective Sergeant Ahmad Singh is a competent person. Detective Sergeant Ahmad Singh does not categorize as a person that the court consider that cannot understand to the question put by court or any other reason under the provision above. Thus, as he is a competent person, then he is compelled to give evidence before the court. Failure to follow the court order, Detective Sergeant Ahmad Singh can be subjected to contempt of court. As conclusion, Detective Sergeant Ahmad Singh is a competent witness and compelled to be testified in the court. In order to identify whether the evidence given by Detective Sergeant Ahmad Singh is basically admissible or not, firstly we need to identify whether the Detective Sergeant Amar Singh is an agent provocateur or just a merely accomplice. Okay, firstly we will refer to Section 40A1 of the Dangerous Drugs Act 1952, where stated that agent provocateur shall be presumed to be worthy of credit for having abetted the commission of an offence by any person for sole purpose of securing evidence against such person. Okay, firstly we'll discuss on what is the definition of an agent provocateur, where we can refer to the case of PP against Rosli bin Rikidin, where in this case the court referred to Black's Law Dictionary that stated that an agent provocateur is an undercover agent who instigates or participates in a crime, often by infiltrating a group involved in suspected illegal conduct to expose and punish criminal activity. The definition also can be discussed in the case of Hari Badugal against PP, where stated that agent provocateur is a person who entices another person to commit an express breach of law which he would not otherwise have committed, and the proceed of informs against him in respect of the offence committed. This case further mentioned that an agent provocateur does not necessarily have to be a police or a government officer. Okay, meanwhile, the accomplice can be defined as a person who participates in commission of a crime but later invited by the court prosecution to give evidence against the accused. As in this case, Davis against DPP, where the accomplice can be a person who within the categories of parties to the crime, receivers in respect of thief, from whom they receive goods, and parties to crime which constitute similar facts. So, whether the Detective Sergeant Ahmad Singh is basically an agent provocateur of an accomplice. So, we can refer to the case of Emperor against Chatterbush Sahu, where it is a case that Tejas Singh and another against PP referred to, stated that where a person make himself as an agent to the prosecution before associating with the wrongdoers or before the actual perpetration of the offence for the purpose of discovering and disclosing the commission of offence is not an accomplice but a spy or agent provocateur. Tajidin and another against PP also referred to the case of R against Mullins, where it said that an accomplice is when he confesses himself as a criminal and may have a motive for giving information and seeking for immunity for his offence. Meanwhile, a spy, or in this context was agent provocateur, may be an honest man who thinks that his act is absolutely essential for the protection of his own interests and the society. A spy does not deserve to be blamed if he investigates offence, no further than by pretending to concur with the perpetrators. Okay, next, applying to the present case, Detective Sergeant Ahmad Singh is an agent provocateur because he is the person who made himself a spy to disclosing the commission of the crime made by Hassan during perpetration of the offence. Detective Sergeant Ahmad Singh acted as a potential buyer of the drugs in order to arrest Hassan during the transaction occurred. All processes of the arrest of Hassan had been prearranged at the very beginning, even before the actual perpetration of the offence, through information given by the informer to him, which continues with a meeting at the restaurant Thai Sedap until the complete transaction of the cannabis at the lane located back of the restaurant. It cannot be said that the Detective Sergeant Ahmad Singh as an accomplice because Detective Sergeant Ahmad Singh did not take part in the offence for sole purpose of buying drugs, but solely for in order to arrest the offender, which is Hassan, based on the information given by the informer. He also acted uh, or run his duty to caught the offender, which is Hassan, in any manner, including being a spy or an agent provocateur. As conclusion, Detective Sergeant Ahmad Singh is actually an agent provocateur who acted as potential buyer to buy the drug from Hassan that had been pre-arranged from the very beginning through the information given by the informer, and thus his evidence should be admissible to the court.
The sub-issue in this case, whether the evidence given by Detective Sergeant Amar Singh as an agent provocateur is admissible to the case. So applying to the law, which is Section 40A subsection 2 of Dangerous Drug Act, stated that any statement made by agent provocateur who is a police officer or any officer of custom, either by oral or in writing, by any person who subsequently is charged with an offence under this act shall admissible as evidence at his trial. For this sub-issue, we had referred to some of the cases. For the first case is Teja Singh and another against PP, where the evidence of police spy or agent provocateur is not that of an accomplice and does not require corroboration. It is a settled law, as per mentioned in Section 40A, that evidence from agent provocateur does not corroboration, thus should be admissible. Next, we would like to refer to the case of T. Tian Si against Pendakwa Raya and also Namasian and other against public prosecutor, which stated that any statement made by agent provocateur shall be admissible, and therefore no requirement for the evidence of the agent to be corroborated different as to the accomplice where their evidence were required for corroboration. In the case of one Muhammad Azman Hassan against public prosecutor, the statutory approval of evidence given by agent provocateur was governed by Section 40A of Dangerous Drug Act 1952. So the federal court has stated that the parliament has deemed it fit that such evidence of an agent provocateur is admissible without restriction, and the judge no longer has a discretion to exclude such evidence. Due to that, there is no need for corroboration of such evidence. Applying to our current case, where Hassan had been arrested and charged under Section 39B, subsection 1A of Dangerous Drug Act. So during the trial, as Detective Sergeant Amar Singh was the agent provocateur who discovering and disclosing the commission of the offence, he need to provide the evidence as to the details of the crime committed by Hassan as an agent provocateur, also subjected to the general rules of evidence and procedure. However, the evidences given by Detective Sergeant Amar Singh shall be admissible inadmissible as mentioned in Section 40A subsection 2 of the Act. So the evidence given does not require for corroboration compared to other type of evidences. So based on the provision and cases mentioned above, the court has no longer discretion to refuse to admit the evidence given by the agent provocateur as the word shall mentioned in the authorities given.
I am Khairunnisa and I will be presenting the second issue for this case. The second issue that arises in the above situation is whether the adverse inference can be drawn against the prosecutor for the failure of the prosecution to call the informer. This issue arises because the prosecution did not call the informer to defense to give evidence at the trial. Next, the sub-issue is what are the effects to the prosecution case for not calling the informer to give evidence at trial. Agent provocateur is protected under Section 40A subsection 1 of Dangerous Drug Acts 1952, where stated that agent provocateur shall be presumed to be worthy of credit for having abetted or abetted the commission of an offence by any person for sole purpose of securing evidence against such person. The issue of whether an informer is a mere informer or an agent provocateur depends on the degree of involvement, which is a question of fact to be determined by the court. Referring to the case of public prosecutor against Chong Chi Kin and another, the informer had to be present twice with the police before the first accused agreed to supply the drugs. The informer also had to make 3 appointments before the police met the first accused. Hence, in this case, the informer is an agent provocateur and could not accord the protection given to an informer under Section 40, subsection 1 of Dangerous Drug Act. The next case referred was the case of T. Chi Hyang against public prosecutor, where the court held that the informer was not a mere informer but an agent provocateur, as he has put in touch with the undercover agent, which the informer is the active instrument who, without his intervention, the accused might never been arrested. Thus, he had lost the protection of disclosure under Section 40 of the Act. The next law referred is Section 40, subsection 1 of Dangerous Drug Act 1952, where it provides the protection of the informers. Subsection 1 of this provision stated that no witness shall be obliged or permitted to disclose the name or address of any informer or making any statement that will lead to the discovery of the witness. Applying to the above case, the involvement of the informer was not merely give the information to the police about the activity of a person trafficking cannabis at Jalan Ipoh, Kuala Lumpur. The informer also had involved in the arrangement of appointment between Hassan and Detective Sergeant Amar Singh at the restaurant Thai Sedap on 18 May 2020. Besides, the informer also accompanied Detective Sergeant Amar Singh meeting Hassan went alone in the restaurant upon reaching the vicinity. The informer also involved with the price discussion of the cannabis before they agreed. Only during Hassan handed the cannabis to Detective Sergeant Amar Singh, the informer did not involve. Thus, it shows that there was high degree of involvement of the informer with the process, which the informer is no longer can be considered as informer, but as an agent provocateur, and the protection under Section 40, subsection 1 of the Dangerous Drug Act 1952 was not applicable to him. In conclusion, it shows that there was high degree of involvement of the informer with the process, which the informer is no longer can be considered as informer but as an agent provocateur, and the protection under Section 40, subsection 1 of the Dangerous Drug Act was not applicable to him.
My name is Nasyuha Binti Ahmad Rizal, metric number 046341, and today I'll be discussing on the sub-issue of what are the effects to the prosecution case for not calling the informer to give evidence at the trial. Firstly, we have to refer to the case of T. Chui Hyang against public prosecutor, where in this case, the testimony of an informer is essential to unfolding of the narrative on which the prosecution case was based, because without the presence of the informer, there will be a gap in the narrative of the prosecution case. Next, the case of public prosecutor against Chong Chi Kin and another, in this case, the court held that the prosecution's failure to call the informer as a witness rendered the whole of its evidence highly suspicious, and at the close of the prosecution case, it fell short of proof beyond reasonable doubt. Moreover, the presumption of trafficking arising from the possession and knowledge of the drug by the accused was rebutted by the superior probability, which could be legitimately drawn from the adverse inference that the accused could have been the victims of a frame-up. Applying to the present case, the effect of the prosecution not calling the informer as a witness will render the whole of its evidence highly suspicious, as it will result to a gap to the prosecution's case. Moreover, the presumption of trafficking arising from Hassan's possessions also might be rebutted by superior probability, which could be drawn from the adverse inference. In the above case, the informer had present with the accused before the accused agreed to supply the drugs. Moreover, the informer also had to make 3 appointments before the police can meet the first accused. Hence, based on the high degree of involvement by the informer was considered as an agent provocateur, and Section 114G of the 1950 Act ought to be drawn against the prosecutions for its failure to call the informer as a witness. Similarly, the informer in the present case had involved in arranging the meeting and also involved in the discussion of the price between Detective Sergeant Ammar and Hassan. Hence, this situation clearly showed that informer is an agent of provocateur, as he involved in every situation that led to the arrestment of Hassan. In addition, the failure of the prosecution to call the informer to the court is fatal, as in the case of public prosecutor against Chong Chi Kin and another, the adverse inference can be drawn against the prosecutions. Next, the definition of adverse inference can be seen in Section 114G of the Evidence Act 1950, where this provision provides that the court will presume the existence of any facts if that evidence which relates to the facts of the particular case could be produced but was not produced, as it will be unfavorable to the person who withholds it. These provisions explain to us that adverse inference can be drawn against any person if they withhold the witness, as it will be detrimental to their case. We can refer to the case of Munusami against public prosecutor, where in this case it was held that the adverse inference under this subsection can only be drawn if there is withholding or suppression of evidence, and not merely due to failure to obtain evidence. In this case, it was also stated that it is not just withholding of evidence, but material evidence, and not just suppress any witness, but material witness to the case. Next, we also have to refer to the case of public prosecutor against Datuk Seri Anwar Ibrahim, where in this case, the court held that in any criminal proceeding, the prosecution has the discretion to choose which witness to call and what documents to produce, provided that there is no hidden motive. Applying to the above case, since the public prosecutor did not produce the informer as a witness during the trial, the defense counsel can draw an adverse inference under Section 114G of the Evidence Act against the public prosecutor, as the court will presume that the prosecution is withholding the witness that is unfavorable to their case. Furthermore, this act will subsequently prove that the prosecution's failure to produce the witness is because of the hidden motive, as mentioned in the case of public prosecutor against Datuk Seri Anwar Ibrahim. In addition to the above matter, the prosecution failure to produce the informer who act as an agent provocateur to the court will resulted to a short of proof beyond reasonable doubt. This is because, applying to the case of Munusami against public prosecutor, adverse inference may be drawn against the prosecutions if it is proven that the prosecution is withholding the material evidence and material witness, which, in the absence of these two evidence, will leave gap to the prosecution case. In the present case, the informer who gave the information and arranged the meeting between Hassan and Detective Sergeant Amar Singh is a material witness. This is because the degree of involvement of the informer to this case is high because aside from arranging the meeting at the restaurant, the informer also invoked in the discussion for the price of cannabis before they agreed. Hence, not producing the witness in this case will make this case fatal, as producing a material witness is important as had been laid down in the case of Munusami. In conclusion, the effect of the prosecution not calling the witness is fatal to the trial and will make the prosecution case short of proof beyond reasonable doubt. As in the present case, the agent provocateur is the material witness to the case, which the absence of the witness will leave gap to the prosecution case. Hence, adverse inference may be applied against the prosecution for the failure to produce the informer to the give evidence at the trial.
So that's all from us. Thank you.